Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor.
Law firms will take this as a retainer.
What? It must be a law firm where they hungry as hell. Now you gonna help me with this parole I'm dealing with?
Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor. With one taste of our premium blends of all-natural ingredients, herbs, and spices, you'll fall in love with meat all over again. Judge Joe Brown's all-natural barbecue sauce collection is made up of 2 zesty flavors, original and spicy. There's only one way to bring order back to barbecuing. Just add Judge Joe Brown's all-natural barbecue sauce and seasoning, and you be the judge.
I want to move on to SCOTUS. We spoke about this briefly last week, but we didn't do a show. So the Supreme Court appears to be ready to uphold Tennessee's ban on youth transgender care. Oral arguments last week, Wednesday, on December 4th morning, a majority of the Supreme Court seemed ready to allow Tennessee to continue to enforce law banning the use of puberty blockers and hormone therapy for transgender teenagers without confronting the higher level of scrutiny required for equal protection concerns. Tennessee Solicitor General argued that the law is simply a medical regulation and does not distinguish based on sex. So Supreme Court is ready to allow Tennessee to continue to enforce a law banning the use of puberty blockers and hormone therapy for teenagers. I think that is a good thing. However, how many justices we have? 9?
9.
And the 3 witches, of course, voted against the ban. And I do want to play audio of.
Well, look. What are you?
Something first before I play the audio.
Okay, I was just going to say it's funny when you hear this. Keep in mind the latest confirmation hearing. Can you tell us what a woman is?
Right.
I don't know what a woman is. See, they were sending signals for this tranny thing.
Well, wait a minute. Oh, this is. All right, so let me play this is the clip. It's 2 clips here.
Being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument. And I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic and in all other being drawn.
So basically, Kentanji Brown Jackson, she compared bans on sex changes for kids on interracial marriage.
Loving is the case. And I remember when that was a live case, and I kept up carefully with the protocols and the arguments, and there's an extremely different situation. You cannot objectively change what you are, okay? Right. What you are becomes obvious because there is no way of disguising it for the most part, though there is a thing called passing. All right?
Mm-hmm.
When there is something that is not blatantly obvious is a status. In other words, we have a situation where you go to a carnival and they say no one shorter than the following mark can get on this ride, you've been there, right?
Right.
Why is that? Because it's a safety matter. In other words, the equipment on this ride is not going to protect or make it safe for somebody of lesser height. This could be a little short person like Judge Judy or a midget, or it can be a child. In other words, I'm sorry, but you just aren't physically big enough to ride this attraction. There's nothing personal. That way, you are permitted to regulate it. You have to be a certain height to get on this ride. Now, if you say you can't get on this ride because you think you are a short person, when actually physically you may be tall enough to get on the ride, you can't say it's discriminatory because somebody says they think they're a short person and not normal height when actually they are. So you can't say we're going to take what their delusion is and base the classificational assessment on their delusion. In other words, are you the 4 feet 6 inches tall that it requires, the 7 inches tall it requires to get on this ride? Or are you in fact 5 feet 2, but you just think you're 5 feet 6, 4 feet 6?
I want to play this second clip.
That it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds.
Oh, I'm sorry. I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning, the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
Can I ask you about one?
So basically, Biden Supreme Court Justice Kentanji Jackson Brown again says there's no difference between giving testosterone to boys and girls. Therefore, and is discrimination.
Look, let's get the extreme thing. See, she's making a classic first-year law student move, which is there's a difference between getting a broke femur and a broke flange in one of your fingers. Law students confuse it all the time. No, the principle is what led to the breakage and whether there's liability, not the severity of the consequences. Let's take it this way. The extreme version of what was said is, why then can't men get hysterectomies?
Right, because
they don't have a uterus,
right,
to get excised. Why can't women get castrated? They don't have testes. So you see, some things, testosterone does certain things on boys, which exemplifies or enhances male characteristics, and estrogen given to the boy does not. So what is the purpose that you are giving a drug that does not do something that's natural to the person?
One last thing on this. It says Supreme Court won't hear parents' challenge to the school's gender identity policies. Wisconsin parents hope the Supreme Court would take their case, arguing schools' gender identity support plans undermine parental authority. But the justices declined, with Thomas Alito and Kavanaugh dissenting. Parents claim such policies bypass them and harm families, even when no child is directly affected. The school argues the parents want courts to issue broad rulings on political issues without real harm. This decision leaves unresolved debates about schools, parenting rights, and transgender student supports, with similar cases already heading for the high court.
Well, in other words, what's going on? Translation, this is press problem here. What's really behind this is the case isn't ripe for adjudication on the appellate level, or at least not their level, and there's some facts that need to be found and put into the record.
So these parents are arguing, parents hope the Supreme Court would take their case, arguing schools' gender identity support plans undermine parental authority, meaning I don't have input as a parent in these gender identity support.
Yeah, that what happened is not going to be dispositive toward the case generally.
Mm-hmm.
It's not right.
Mm-hmm, mm-hmm.
In other words, it's still growing, and you got to find out. So I can see the parents, and I happen to agree with the conservative majority with their assessments. You might as well. And what's going on with the bare bones 6 is something that is interesting, and it's this. It goes along with this thing we have had so much of in the last 50 years, where the litigation has gotten more and more complex, more and more convoluted, and more expensive. In other words, who can afford it these days with lawyers and everybody else charging such exorbitant fees?